The ability of the parties to obtain documents, witness statements, and other discovery is generally more limited in arbitration than in a court proceeding. So they're basically telling me like, hey, this is not the best idea, but I suggest you sign if you want to use our app. Welcome back to Wine and Chill, your home for all things legal shenanigans. I'm Stephanie, your friendly neighborhood lawyer. Well, as you know, not your lawyer, which brings me quickly to our disclaimer. By watching this video, you understand and acknowledge that this video is for entertainment purposes only, and also you agree that you have read the full disclaimer down below in the description box. So, today, we're gonna hop right into it. You're probably very familiar with this case and what is going on. The most impactful thing of this week in 2021 has been the discovery of the subreddit Wall Street Bets. And by discovery, I mean the extra 2 million people that decided to join, and then the nosy busybodies like me that are just reading through the Reddit and don't have Reddit on their phone. So through the collective action of we, the 99%, aka we the poors. So due to the collective action of the 99%, fueled on by the Wall Street Bets subreddit, the price of Gamestop, AMC, BlackBerry, a few other stocks have risen, most noticeably Gamestop, much to the chagrin of Wall Street and hedge funds, which brings in this lawsuit. There are a lot of great articles, background on YouTube just talking about what's going on. Specifically, you don't really need to understand the financial mechanics to understand this lawsuit, but it will make sense. So I'm gonna link a few videos that I found super helpful below that describe what a short is. Today, we are gonna focus on 3 things. So there is a class action lawsuit now against Robinhood by, it's not just the people in that Reddit group, it technically applies to anyone that has owned or tried to buy a GameStop share and is a customer of Robinhood. It did start, however, with the subreddit Wall Street Bets, which they then made, I'm not sure the Reddit proper terms, they then made another subreddit specifically about the lawsuit. Then they filed the lawsuit, so kudos to them. So we are gonna go through what is a class action. This is the first time we're covering this on my channel. Next, then we're gonna go through the case. The actual complaint is only 9 pages, so. And then we're gonna go through the Robinhood Customer Agreement, basically the terms and conditions that are listed on their website, because specifically 2 of the clauses and whether they preempt the lawsuit altogether or what are the workarounds around that. Ready? Let's go. For those of you that are new to my channel, as usual, while we go through the case, I am going to put the lawsuit and the Robinhood Customer Agreement. It'll go to the side of me so you can read along, and then I'll link it down below as well in the description box. First and foremost, what the heck is a class action? Most people are basically familiar with what a class action is, but just in case you're not, so a class action is a lawsuit filed or defended by an individual or a small group on behalf of a large group. So basically, this class action was filed by this man in Massachusetts, and he is going to be suing on behalf of the larger group. So, class action, of course, there are rules. Not everyone can just say, hey, me and 10 of my friends, we want to sue our college for charging us so much money. And no, you can't. That's not necessarily how it works. So there are rules for class action. They are governed by the Federal Rules of Civil Procedure, FRCP, which I haven't looked at in a long time. So FRCP specifically, Rule 23. So there are 4 pillars that a class action lawsuit needs to meet in order to be certified, to be a certified class. If you are not a certified class, you cannot bring a class action, which means individually all of these people who are trying to sue would have to sue individually, which would be costly, and also it creates a bunch of rigmarole and issues. So the 4 pillars under class action are going to be numerosity, commonality, typicality, adequate representation. What do those mean? Don't worry, I got you. Numerosity, simple, number of plaintiffs. Some courts have ruled you need to have at least 40. In this case, when we go through the case, we'll see there are about 100 plaintiffs so far. You know when you watch TV late at night and it's like, have you gone outside in 2020 and breathed the air? You too can sue, etc., etc., etc. That's basically class actions trying to hit the numerosity prong and make sure there are enough people. This was probably likely going to happen in this Robinhood case. It's going to be much more people signing on to be a plaintiff, which is going to be interesting. Commonality. Claims must have a common question of law, at least one. So we're going to go through here. There are numerous common questions of law because one of the things that we're going to go through that the plaintiffs are claiming is that not only is this a breach of contract claim, but also that Robinhood has violated certain FINRA regulations as a broker by not allowing people to trade. So number 3, we have typicality. So typicality is basically saying like, hey, your claims and my claims are the same. So we are all together suing for breach of contract. We are all together suing for harassment. We are all together suing for this. And then 4 is adequate representation. The person that is the original plaintiff is technically representing the class. The claim is going to then just track the language. The proponent of a class certification must also show that a class action is superior to other means of litigating the case. This is important because, as we're going to talk about at the end, there is an arbitration clause in the Robinhood Customer Agreement. So this case is going to have to show that, hey, we need federal court. We need to be a class action, because if we go to arbitration, that is not the best way to hear this case. Arbitration clauses are a point of contention for consumer rights groups, and in my opinion, I'm not really a fan of arbitration clauses either. For various reasons, we'll go through them. With this case, there are 4 causes of action, which are pretty standard causes of action. 1, breach of contract. 2, breach of the implied covenant of good faith and fair dealing. 3, negligence. 4, breach of fiduciary duty. In this instance, so regarding number 4, in this instance, Robin is the fiduciary, and they have a duty to allow the people that sign up to their platform, since they're an online brokerage, to allow said people to trade. For full background, and just as a caveat on my end, I do not have Robinhood. However, I did notice that E-Trade was acting a little funky when I too was trying to get some money for Sally Mae. I think what's going to happen is this case is going to expand to other stocks besides just Gamestop is currently the only one that they're contending. I think it's also going to expand as a larger class action lawsuit against other online brokerages. Let's get into the background of the case. We'll start with paragraph 2, and remember, everything in here is an allegation. So, FYI. Robinhood purposely, willfully, knowingly removing the stock GME from its trading platform in the midst of an unprecedented stock rise, thereby deprived retail investors of the ability to invest in the open market and manipulating the open market. That sentence needs a little work, that's fine. Y'all get the point. They are claiming, in this case, that Robinhood is actually manipulating the market by not allowing people to invest in GameStop, and by not allowing we the common people to do what the hedgy hedge funds have been doing all this time. If it's good for the 1%, it's good for the 99. All right, so we're gonna skip down to the party. It's gonna list out the specific person, so I'm not gonna read his name just in case for privacy reasons. He's gonna be the representative. So now we're gonna go, we never really covered jurisdiction venue, but this is important in this specific case because it's a class action lawsuit. So we're gonna go down to paragraph 8, jurisdiction and venue. So the aggregate claims, second sentence, the aggregate claims of all members of the proposed class and subclasses are in excess of $5 million, exclusive of interest and costs, and there are more than 100 putative class members. Many members of the proposed class are citizens of a state different from defendant. Because remember, we're trying to show that, hey, it's better for us. They're suing an SDNY, Southern District of New York, in federal court, and they want to get out of arbitration. That's going to be the biggest hurdle here. So it's going to be completely reiterating over and over and over again, like, hey, we need to sue here in this venue. All right, paragraph 9. This court is a proper venue for this action because a substantial part of the events, omissions, and acts giving rise to claims herein occurred in this district where Robinhood distributed, marketed, advertised, and sold the trading services which are the subject of the present complaint. Finally, venue is appropriate in this district because a substantial part of the acts and omissions that gave rise to this complaint occurred or emanated from this district. Robinhood is based in New York. They're suing in New York. You get the drift. So let's go down to the alleged market manipulation. Paragraph 16, on or about January 27, 2001, Robinhood, in order to slow the growth of GME and deprive their customers of the ability to use their service, abruptly, purposely, willfully, knowingly pulled GME from their app, meaning retail investors could no longer buy or even search for GME on the Robinhood app. Yes, this occurred. There are multiple reports of it. People are taking screenshots of it because, of course, that will be evidence further when this passes the hurdle of staying in district court, when this passes the hurdle of staying in the actual court system versus going to arbitration. And I'm saying when. hopefully for them. Not gonna read all of it because I'm sure you guys have followed this in the news, so you're very familiar with it. Paragraph 21 is interesting, and this one is gonna be important. The Financial Industry Regulatory Authority, FINRA, which governs brokers like Robinhood, espouses Rule 5310 regarding best execution and interpositioning. Rule 5310.01 requires that Robinhood must make every effort to execute a marketable customer order that it receives promptly and fully. By failing to respond at all to customers placing timely trades and outright blocking customers from trading a security, Robinhood has breached these among other obligations and caused its customers substantial losses due solely to its own negligence and failure to maintain adequate infrastructure. So that is a claim in paragraph. Remember that FINRA regulation 5310, because that regulation is technically at odds with one of the terms in the Robinhood Customer Agreement. Under class action allegations, you're gonna see them tracking the language, because remember, we need numerosity, commonality, what were the other two? Typicality and adequate representation to be classified under a class action. On page 4, starts tracking the language and saying like, hey, we meet these specifications because. So numerosity, there are 100 people so far in the class. I'm assuming that is definitely gonna grow. There are way more people that use Robinhood that also try to trade GME. Commonality, what I'm only gonna go through the commonality section because I think it's really interesting. So basically, commonality is showing the common questions of law and fact. So some of the questions are, now this is gonna be different from the cause of action. So the cause of action is breach of contract, but there are questions of law that also need to be answered. So that's what's specific to a class action versus just a regular lawsuit. So let's go to D, actually, 31D. Whether Robinhood violated FINRA Rule 5310, this is important, remember FINRA Rule 5310, among other FINRA rules, state rules, and federal regulations. E, whether Robinhood violated consumer protection laws and failing to disclose that its services would not include the ability to trade on GME and other securities for a substantial period of time. So it's gonna continue on. Important. So now remember, as you all know, I'm a tech lawyer, tech attorney, corporate counsel. It's all the same thing. That's what I do. So looking at customer agreements, tech company T's and C's is basically what I do all day and negotiate against them. So this brought me a lot of joy to be able to do that for you guys. There are going to be two big issues in this case. Notwithstanding the claims, the issue of whether or not this case can even be heard is going to be the main issue. Two reasons. One, there is a giant arbitration clause on page 29 that everyone that is a Robinhood customer has already agreed to. And then two, also on section 16, there's a section on restrictions on trading. You're gonna go through both of those and the potential hurdles that this case may face, and maybe potential remedies, how to rectify them. So how does this work? How did all of these people, at least 100 people, and every Robinhood customer, which is most likely in the millions, agree to this? This is a click-through agreement. Basically, whenever you sign onto an app, do you agree to the terms and conditions? Boop, 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 you just click through. It's the same thing like me telling you, like, you have read the disclaimer below. Did you read it? I don't know. Did I tell you to read it? I did. The same thing with this. Most people do not read the T's and C's, the terms and conditions, TOU, terms of use, customer agreement. They're all the same thing. Most people don't read them because it is irrelevant to their usage in the fact that if you agree or disagree with the T's and C's, the terms of use, or the customer agreement, and you want to use the product, it's irrelevant, your disagreement, because you cannot negotiate against them. That's how they're set up. That's why they're click-throughs. So most people take that as a fact of like, well, I really want to use the Robinhood app, or well, like I really want to use Instagram, so I guess I'm just going to agree to all of this. As a consumer, you have to agree or you can't use the product. So that doesn't make it right, to be honest. And this is always a point of contention in some of the startups I've worked at, that sometimes they want to change to click-through agreements. And the downside from a business end, click-through agreements are great. You click through, you know that everyone agreed. You are now in contractual privity between you and millions of customers. You agreed. I didn't tell you not to read it. You agreed. You're done. We're done with this. From a customer standpoint, it's obviously not the best experience because you would never agree to all of this. You just wouldn't. So, which goes to my next point. Even though the arbitration clause is in here, that doesn't mean that the arbitration clause is full and final, and it doesn't mean it can't get thrown out. So arbitration clauses do get thrown out in court sometimes. So what is arbitration? Arbitration is a private process and a form of alternative dispute resolution outside of the court system. So pros and cons of arbitration, to be quite frank. Pros, as a big businesses love arbitration because A, it's generally cheaper than litigation, and more importantly to the big business, arbitration is not public. Whatever happens in arbitration, there is no duty to disclose to the public. There's no duty to disclose the findings. Everything is confidential in most arbitrations. I was like arbiters. Arbiters, which are like the judges in arbitration, arbiters' rulings are final. You can't litigate them in the court. So that's why big businesses love arbitration. Arbitration on a positive end can be positive in that when you sign certain arbitration agreements, it will specifically state that the arbiter, so that's the person overseeing everything, has to be someone who has understanding of the case, understanding of that certain industry. So that can help. Judges see cases from tort law, murder, class action, discrimination, contract disputes. Judges see everything. They are not experts in everything. It's impossible. Whereas an arbiter most likely is like, okay, I'll only arbitrate for tech companies. I'm only the arbiter for certain tech claims in the SaaS industry because like that's what I know like the back of my hand. So just so you know, pros and cons. Consumer rights agencies are always pushing against arbitration because arbitration is not good for consumers, to be honest. Say I use a shampoo and the shampoo turns my entire hair blue. Obviously I would freak out, first of all. Second of all, when I go to sue, if there's an arbitration clause, I would have to go through the arbitration process. Whatever happens, whatever money I win, whatever the brand admits to, that will never leave outside of the arbitration. So say then somebody else uses the same shampoo, their hair turns blue, you keep doing the process over and over again, when in reality, a class action lawsuit would solve all of that. Everybody whose hair is blue could just sue the brand, the shampoo brand, one good time, and then it would be known like, hey, these people are using, nonsense in their products. Arbitration doesn't allow for that because you can't have class action lawsuits in the arbitration. Yeah, it's not consumer friendly. So with that being said, let us look at the clause. So section 38 of the customer agreement, here we are, which is gonna be page 29. That paragraph is super long, so I'm gonna leave it right here on the screen so you guys can read it. I'm not gonna read you the whole thing because that's pointless, but we're gonna talk about certain parts of it. So this agreement contains a pre-dispute arbitration clause. By signing an arbitration agreement, the parties agree as follows. There is no technical signature, like this is a click through. I can guarantee you the most people that have signed this have not read this. All parties agree this agreement, you are giving up the right to sue each other in court, including the right to a trial by jury, except as provided by the rules of arbitration form in which a claim is filed. 2, arbitration awards are generally final and binding. You cannot appeal in this. Arbitration awards are generally final and binding, so no appealing. A party's ability to have a court reverse or modify an arbitration award is very limited. It's also written very vaguely. The ability of the parties to obtain documents, witness statements, and other discovery is generally more limited in arbitration than in a court proceeding. So they're basically telling you like, hey, this is not the best idea, but I suggest you sign if you want to use our app. The arbiters do not have to explain the reasons for their award unless, in an eligible case, a joint request for an explained decision has been submitted by all parties to the panel at least 20 days prior to the first scheduled hearing date. That's important. So basically, if the class action lawsuit gets thrown out, that SDNY says, hey, this arbitration clause is preempting all of you from doing this, you all need to go through arbitration, everyone will unfortunately then have to go through arbitration. You can't appeal. You can't tell anyone how much money you got. It's not fair because everyone is claiming the same harm. Here we go. We're in the middle of it. I agree to arbitrate any controversy or claim before FINRA DR in the state of California. This agreement to arbitrate constitutes a waiver of a right to seek judicial forum unless such waiver would be void under federal securities law. So it's going to go through all things. The arbiter they selected is at least FINRA specific. So these people the one positive of that is these people are very familiar with securities regulation. They know how this works. They know what should be done. However, You relegating Joe Smo and Stephanie and regular people who all live across the United States to arbitrate in California is prohibitive, because most people are like, listen, I was selling GME stock and getting GMA stock to pay my basic bills. I can't come to California to do this. So it's designed in a way that is not consumer friendly and is not necessarily fair to the consumers, which is why sometimes arbitration clauses get thrown out. So while it is there, while it is a huge wall to climb, it is not an impossible wall. So important to state that. So then so now that we've just talked about arbitration, in order to get out of arbitration and to get into the court system and into federal court, one of the things under FRCP 23B3 that we had mentioned earlier, the class is going to try to use predominance and superiority, basically saying like, hey, we can't be in any other venue because this is the only venue that is going to work for us. So we're going to go back to the lawsuit. So switch your tabs. We're gonna go back to the lawsuit, paragraph 34, the predominance and superiority. There is no plain, speedy, or adequate remedy other than by maintenance of this class action. A class action is superior to other available means, if any, fair and efficient adjudication of this controversy. Prosecution of separate actions by individual class members would create the risk of inconsistent or varying adjudications, establishing incompatible standards of conduct for the defendant. So, like my example with the blue hair. What if the court decided like, you know what, Stephanie's hair was just living its best life, give her 50 grand. And then what if it gave somebody else and they're like, and then what if my dad sued because the few hairs that are on his hair, my dad is mostly bald, sued and the court's like, well, you know, sir, you didn't really have that much hair anyway, and then gave him $10, like I'm pretty sure he would be like, what the hell, the standard is 50 grand. So that's important. So now, second hurdle that we're gonna go through, remember FINRA, what was it, 5301? See, I told y'all to remember, now I'm like, 5310. Okay. We are on page 11 of the Robinhood Customer Agreement, section 16, restrictions on trading. So FINRA 5310 that we talked about earlier states, in part, it's the best execution and interpositioning rule, 5310.01. Robinhood must make every effort to execute a marketable customer order that it receives promptly and fully. Okay, so that's the FINRA rule, a section of it that the lawsuit is referencing. Then in section 16 of Robinhood's Customer Agreement, restrictions on trading, it states, I understand that Robinhood may, in its discretion, prohibit or restrict the trading of securities or the substitution of securities in any of my accounts. What's important is, again, these are click-through. Everyone agreed to them. Doesn't make them right. It doesn't make it right just because you sign something, which y'all know I love to just stand on the damn podium and say that all day, every day, because that's generally the number one pushback of people whenever we're talking about breach of contract claims. Well, they signed it. When we talked about Kanye and his contract, well, he signed it. So just because you sign something, if you are the party in the lesser power position and you are the party that can be taken advantage of, that doesn't make it correct that somebody exploited that and was like, well, I know you're gonna sign it, I'm just gonna say whatever I want in here. It doesn't make it okay. So yes, in this customer agreement, Robinhood is allowed to, in its discretion, prohibit or restrict the trading of securities. However, what is going to predominate, Robinhood in their customer agreement or a FINRA regulation? Likely the FINRA regulation, which says you have to reasonably execute on the securities that your customer is trying to buy, sell, or trade. It is going to be interesting to see how this plays out. While I do think there are some hurdles in this case, I think they can be overcome because it is unprecedented to see this amount of cohesion and unity among people. Love to see it. This amount of cohesion and unity among Republicans and Democrats in both the Senate and the House that are basically seem to be championing, we the people, the consumer, the 99% who, to be honest, look at this, just peruse around Wall Street Bets, the subreddit, and you see what people are doing with the money. People are just trying to get by, and these hedge funds exploiting companies not to get by, to be ultra rich and living to do nonsense. And yes, I will be very honest. I did try to buy a few, because I too owe a shit ton of money to Sally Mae, as you all know. So if you have any questions, let me know below. We will be following this case closely. So hopefully we'll have some updates. We will see if the class action does indeed become a certified class or whether or not the judge pushes them into arbitration. I think it's gonna be very contentious if they push them into arbitration, but at some point, the American government has to start working for the American people. At some point, one would hope. We pay enough money in taxes for people to do their job. So we shall see what happens. And as usual, thank you for joining in and for watching. If you haven't already, please go ahead and like and subscribe. Oh, one more thing I remembered. So before, because I know you guys might preemptively ask, and I saw that apparently a bunch of well-intentioned human beings, apparently well within their right, 100,000 or so people decided that they were going to give Robinhood a 1 star on Google, and Google then deleted 100,000 reviews, which is preposterous. Like, clearly the app, either they did it on purpose or it doesn't work. Either or is not good from a user standpoint, so you should be allowed to give them a 1. And Google deleted all 100,000 reviews. Yes, I looked through Google's terms of use. When you are leaving reviews, they are allowed to delete reviews according to them, because again, these companies write their own terms of use. And by these companies, I've written many terms of use. So yeah, it's the company's attorneys who write these terms of use, and they write them in favor of the company, of course. That's how that works. So Google has a section that states that they are allowed to remove reviews that they feel are intended to manipulate the rating. So they are relying on that, which is why they removed all those reviews. I don't agree with that. What is manipulating the rating by telling the truth that, hey, this app is crap? I tried to do something with the app didn't let me do it. It's supposed to let me do it. It's a bunch of nonsense. But there's always a workaround. There's always a workaround. So just putting that in there. But if you haven't already, please go ahead and like and subscribe and let me know. What do you think? Do you think that SDNY, the Southern District of New York, is going to certify this class as a class action, or do you think that they're going to push them into arbitration? I always take the pessimistic route, but I'm hopeful. I am kind of rooting for them, to be honest. I take the impartial road, but I am rooting for them. I am. So we'll see. Let me know in the comments what you think.